Good afternoon. First, I want to thank the University of Richmond School of Law and particularly JOLT for inviting me here this afternoon and also for putting me last on the program so that I'm the only barrier between you and the reception. I'm going to talk today about competence in the context of the obligation to preserve evidence and the sanctions that may befall a party or counsel when that evidence is destroyed. And in doing this, I'm going to build on the presentation that Lauren made this morning and on the remarks that Gail made during our panel earlier this afternoon. Unfortunately, I have a good deal of experience with spoliation, that is, with the sanctions that follow from the destruction of evidence. As Phil gave me away earlier today, I've been on the bench for more than 30 years, and during that time I've had a fair number of spoliation cases. You can see that I've had published opinions as early as 1991. Now, that one was not an electronically stored information case, but the balance of the cases listed there are. And they have continued up to as recently as last month when I issued a decision under New Rule 37E. Now, judges have a time-honored tendency to act as if they're conducting empirical analysis even when they're engaged in rank speculation. In that spirit, I want to start with a null hypothesis. And that hypothesis is that because Amended Rule 37E has reduced the threat of severe sanctions for spoliation, counsel will exercise less competence in the preservation of electronically stored information. So we're going to examine that hypothesis and see if we can prove or disprove it. But before we address the specifics of the analysis, I want to ask, why do lawyers and other human beings attempt to act competently in the first place? And I have a fairly complex model for answering that question. That's the model. I would suggest that competence can be viewed as a stool, and the stool has three legs: rewards, sanctions, and norms. You attempt to act competently in part because you expect certain benefits or rewards to flow from that conduct. You may also act competently because you fear the sanctions that would follow if you don't. You act incompetently, you do something wrong, something bad happens. So there's, on the top there, you have that reward and sanction, the carrot and stick, if you will. But you also have norms. Unlike the top two factors, which are extrinsic, norms are basically intrinsic values that people have that would tend to motivate them to operate in a certain way. And in this case, we would ask what norms motivate you to favor competent behavior. So if you would, keep this model, the stool, in mind as we talk about the law. Just to review what we talked about a little bit this morning, the basic obligation to preserve evidence arises when a party reasonably anticipates litigation. That hasn't changed under Rule 37E. And as the notes here indicate, the common law duty to preserve persists. That wasn't necessarily going to be the case. The Rules Committee strove mightily to address the issue that we talked about earlier, which is the trigger. The Rules Committee calculated that it would be quite valuable to counsel and to the parties to have a better idea of when they had to begin preserving information in connection with litigation. And that's not an easy question to answer. Let's take your typical employment discrimination case. An employee is terminated. Well, at that point in time, it becomes more likely than it had been previously that that employee is going to initiate a litigation. Does that give rise to a preservation obligation? Perhaps. On the other hand, probably 99% of all terminated employees never bring an action. So this employee is disgruntled and brings an internal complaint to the effect that they were discriminated against, and that's why they were fired. Well, that makes it somewhat more likely that there will be litigation, but is that enough to create an obligation to preserve? Take another step along the line. The employee doesn't get satisfaction when he or she files the complaint internally, so they arbitrate it or grieve it, depending on what's available in the contract. That doesn't work. They then bring a complaint to the EEOC. Still not litigation, but it's certainly a lot closer to bringing a lawsuit. So you can see that in that circumstance, and I would suggest in many, there's a spectrum, and it makes it very difficult for a party to determine where on that spectrum the obligation to preserve arises. And the Rules Committee attempted to address that, and it utterly failed. And it failed for two reasons. It failed because there was a marked lack of consensus with respect to whether the trigger point should be early or late. That is, closer to the point where the employee is terminated or closer to the point where the employee actually files a case in court. And secondly, the committee recognized that there are a myriad of contexts in which the preservation obligation arises, and it's really, really hard to create a single rule that would address all of those contexts. So the committee threw up its hands and said, we can't really deal with the front end of the preservation problem, so let's deal with the back end. Let's deal with the sanctions that flow from the violation of the preservation obligation. So what did those sanctions look like before the new rule? Basically, and the sanctions regime arose out of the common law. And those rules said that if a party has control of evidence it was obliged to preserve at the time that it was destroyed, the records were destroyed with a culpable state of mind, and the destroyed evidence was relevant such that it was likely to have favored the innocent party, then serious sanctions could be imposed. By serious or severe sanctions, I mean dismissal, default, or the imposition of an adverse inference. An adverse inference is simply telling the jury that it either may or must infer that the missing information would have been unfavorable to the party that destroyed it. Okay? Those are what we call the most severe or drastic sanctions, or in some cases, case-terminating sanctions. Now, in some circuits, including my own, when we talk about a culpable state of mind, that included negligence. The Second Circuit said that you could impose severe sanctions even for the negligent loss of evidence because the risk of the loss of the information should fall on the party that lost it, not on the innocent party. So even the negligent loss of information could result in severe sanctions. And some courts, and again including my own, established some bright line rules with respect to how parties were required to comply with the preservation obligation. In this case, Judge Shinlin said that the failure to issue a written litigation hold constitutes gross negligence. And since it constitutes gross negligence, it could lead automatically to the imposition of severe sanctions. Now, in the face of these sanctions threats, the Rules Committee had previously instituted the old safe harbor. That was old Rule 37E. Well, it turned out not to be very safe. Basically, all it did was protect a party that had lost information because it had inadvertently failed to turn off the auto-delete. Right? That's what the loss as a result of the routine good faith operation of an electronic information system referred to. And I will say that during the period from 2006, when that rule went into effect, till the new rule went into effect at the end of 2015, there were probably 3 or 4 cases in which a party successfully relied on the old safe harbor. It was not very successful. And indeed, parties began to complain about the substantial costs and burden that they were incurring preserving information that almost certainly would never be used for trial, and yet they were facing a threat of draconian sanctions if in fact they disposed of the information and the court found that that had been improper. And the Rules Committee responded with new Rule 37E. And new Rule 37E really has 3 parts. The first, which is on the screen, consists of the threshold requirements for imposing the remedies and sanctions under the rule. We must be talking about electronically stored information that should have been preserved. That is, there was a preservation obligation in place. The party who lost it failed to take reasonable steps to preserve it, and the information can't be restored or replaced. If those threshold requirements are met, you move to the next part of the rule, which provides basically that a court can then enter a remedy, but it must be the least drastic remedy sufficient to cure any prejudice to the innocent party. Fair enough. Then things get interesting, because only when the court finds that the spoliating party acted with the intent to deprive another party of the use of that information in the litigation, only under that circumstance may the court impose the drastic sanctions, dismissal, default, or an adverse inference. So this would seem to make severe sanctions a much more remote risk, and therefore motivate counsel to be less vigilant about preservation. Well, not so fast. There are significant remaining consequences that are still available even for innocent spoliation. The first is preclusion orders. A court may still, even without a showing of intent to deprive, preclude a spoliating party from introducing certain evidence or from advancing certain claims or defenses. That can be a very potent sanction if the evidence destroyed goes to a critical issue. Obviously, the result of a preclusion motion or preclusion order in that circumstance may be the functional equivalent of dismissal or default. And those are two examples of cases in which I've issued preclusion orders, the first obviously preceding the new rule, but the second one having been issued after the new rule was in effect. The court may also still allow a party to introduce the evidence of the spoliation. So even if there is no adverse inference, the innocent party can still introduce evidence of what occurred. That is, that the other side lost potentially important information. Well, that's sort of adverse inference light, right? You put in everything to the jury except that the judge doesn't say that the jury can find that that information would have been harmful to the spoliating party. But you can bet that the attorney for the innocent party is going to make that argument over and over to the jury, so the effect may not be all that different. Now, the new rule also introduces additional uncertainties that I would suggest motivate counsel to continue to try to be competent in preservation. First of all, you have to determine whether we're talking about electronically stored information at all. If you're not, if the information that's lost is not electronically stored information, you're not in the rule at all, you're back under the common law. So to take the black box that we've been talking about, the black box in the car, suppose the car is lost, destroyed following the accident. Certainly the car and perhaps even the black box itself is physical evidence, and yet the information contained within it may be electronically stored information. So it may fall in the potentially more serious sanctions. Okay, but at least if you're in federal court, your sanctions are going to be limited by the four corners of Rule 37E, right? 37E forecloses reliance to determine when certain measures should be used? Well, maybe not. The Supreme Court has said that if the rules are not up to the task, the court has the inherent authority to impose sanctions. So I would think that in circumstances where the rule doesn't apply because you don't get past the threshold requirements of 37E, and where there is a threat to the integrity of the system of justice, perhaps because of the bad faith of the spoliating party, you can still get case terminating sanctions even outside of 37E under the inherent power of the court. So, 37E may not entirely relieve the sanction incentive to be competent. What about the other legs of our stool? There are at least two benefits to competence independent of 37E, right? First of all, if you're competent, you can better understand the balance between the costs associated with preservation and the risks involved in deleting information. So you can present to the business people the argument for either preserving or deleting information. And, as was alluded to earlier, some of that information out there may be favorable to you. So you need to be able to analyze it and determine whether information should be preserved because it would be to your benefit. And now we come to the third leg of the stool, which is the norms. Back in 1985, Professors Deci and Ryan at the University of Rochester wrote a book called Intrinsic Motivation and Self-Determination in Human Behavior. And they identified three motivators for human behavior, one of which was the desire to be competent. So they identified this as an intrinsic value, something that human beings strive to do independent of the external risks and rewards. And as we've already discussed, this particular norm is embodied in the legal norms that we call the Model Rules of Professional Conduct. And I won't labor over this because we've discussed it a number of times. It's in the Comment to Rule 1.1 as well as in the rule itself, and it now refers specifically to technology. And the California Bar Opinion has identified the aspects of electronic discovery to which the rule applies, including being able to implement appropriate preservation procedures for ESI. So I would conclude that 37E does not, first of all, significantly reduce the threat of sanctions because there are residual remedies available under the rule itself, because the rule creates additional uncertainties which are going to make it more important to be competent, because state law is out there and is going to be an important source of sanctions in many circumstances, and because the inherent authority of the court may be available where Rule 37E does not apply. So the first leg of the stool, I think, has not been as significantly weakened by Rule 37E as some might think. Secondly, good preservation practices yield positive benefits. Therefore, it's important to be competent in order to avail yourselves of those benefits. And third, legal norms continue to favor competent preservation. So to return to our pseudo-scientific paradigm, the null hypothesis is rejected. Counsel will not be more lax in meeting their obligations to preserve electronically stored information. Thank you. I'm happy to take questions. Anybody? Anybody in the choir? If not, enjoy your break.
Hi everyone, I'm Jim Gibson. I'm on the faculty here and I have the pleasure of being the faculty advisor for JOLT, and I want to just thank all the participants and panelists for coming, except Judge Francis, who stole my joke about being the last thing between you and the reception. Most of all, I want to thank the organizers here at JOLT, and particularly Eileen Waters. It takes a lot of effort to make something look this effortless, and just give them a final round of applause, and then it's beer and wine. Thanks. Have a good weekend, and please join us for the reception in the atrium.